5 seconds to go. Start. Hence, each case is required to be dealt with on its own facts and circumstances. It could thus be seen that this court observed that in cases of alleged abatement of suicide, there must be a proof of direct or indirect act of incitement to the commission of suicide. It has been held that since the cause of suicide, particularly in the context of the offense of abatement of suicide, involves multifaceted and complex attributes of human behavior, the court would be looking for cogent and convincing proof of the act of incitement to the commission of suicide. This court further observed that a mere allegation of harassment of the deceased by another person would not suffice unless there is such action on the part of the accused which compels the person to commit suicide. This court also emphasized that such an offending action ought to be proximate to the time of occurrence. It was further clarified that the question of mens rea on the part of the accused in such cases would be examined with reference to the actual acts and deeds of the accused. It was further held that if the acts and deeds are only of such nature where the accused intended nothing more than harassment or a snapshot of anger, a particular case may fall short of the offense of abatement of suicide. However, if the accused kept on irritating or annoying the deceased by words or deeds until the deceased reacted or was provoked, a particular case may be that of abatement of suicide. This court held that owing to the fact that the human mind could be affected and could react in myriad ways, and that similar actions are dealt with differently by different persons, each case is required to be dealt with its own facts and circumstances. In the case of Sanju alias Sanjay Singh Sengar Supra, the appellant before this court was charged with having abetted the suicide by his brother-in-law sister's husband. The prosecution's story was that there were strained relations between the deceased and his wife, who at the material time was staying with the appellant therein. On 25th July 1998, the deceased went to the appellant to bring back his wife. There was a quarrel between the appellant and the deceased, who came back alone. The deceased told his brothers and other acquaintances that the appellant had threatened and abused him by using filthy words. On 27th July 1998, the deceased was found dead. The deceased left a suicide note which showed his disturbed state of mind, but otherwise he blamed the appellant for the suicide. The appellant's petition for quashing of the charge sheet filed under Section 482 CRPC was dismissed by the High Court, which led him to file an appeal before this court, which came to be allowed. While taking note of the disturbed state of mind of the deceased, as was evident from the suicide note, and the lack of intention on the part of the accused to abet the commission of suicide by the deceased, the court held that there was a time gap of 48 hours between the abusive language being used and the commission of suicide. As such, owing to the passage of 48 hours, giving the deceased enough time to reflect, there was no proximate link between the words uttered and the act of suicide. This court observed as follows. In Swami Prahalad Das versus State of MP 1995 Supplementary 3 SCC 438, the appellant was charged for an offence under Section 306 IPC on the ground that the appellant during the quarrel is said to have remarked to the deceased to go and die. This court was of the view that mere words uttered by the accused to the deceased to go and die were not even prima facie enough to instigate the deceased to commit suicide. In Mahindra Singh vs. State of MP 1995 Supplementary 3 SCC 731, the appellant was charged for an offence under Section 306 IPC, basically based upon the dying declaration of the deceased, which reads as under SSC page 731 para 1. My mother in law and husband and sister in law, husband's elder brother's wife, harassed me. They beat me and abused me. My husband Mahindra wants to marry a second time. He has illicit connections with my sister in law. Because of these reasons and being harassed, I want to die by burning. This court, considering the definition of abetment under Section 107 IPC, found that the charge and conviction of the appellant for an offence under Section 306 is not sustainable merely on the allegation of harassment of the deceased. This court further held that neither of the ingredients of abetment are attracted on the statement of the deceased. In Ramesh Kumar vs. State of Chhattisgarh 2001 9 SCC 618, this court was considering the charge framed and the conviction for an offence under Section 306 IPC on the basis of dying declaration recorded by an executive magistrate in which she had stated that previously there had been quarrel between the deceased and her husband, and on the day of occurrence she had a quarrel with her husband, who had said that she could go wherever she wanted to go, and that thereafter she had poured kerosene on herself and had set herself on fire. Acquitting the accused, this court said, SEC page 620, a word uttered in a fit of anger or emotion without intending the consequences to actually follow cannot be said to be instigation. If it transpires to the court that a victim committing suicide was hypersensitive to ordinary petulance, discord, and differences in domestic life quite common to the society to which the victim belonged, and such petulance, discord, and differences were not expected to induce a similarly circumstanced individual in a given society to commit suicide, the conscience of the court should not be satisfied for basing a finding that the accused charged for abetting the offence of suicide should be found guilty. Reverting to the facts of the case, both the courts below have erroneously accepted the prosecution's story that the suicide by the deceased is the direct result of the quarrel that had taken place on 25th July 1998, wherein it is alleged that the appellant had used abusive language and had reportedly told the deceased to go and die. For this, courts relied on a statement of Sashi Bhushan, brother of the deceased, made under Section 161 CRPC when reportedly the deceased, after coming back from the house of the appellant, told him that the appellant had humiliated him and abused him with filthy words. The statement of Sashi Bhushan, recorded under Section 161 CRPC, is annexed as Annexure P3 to this appeal, and going through the statement, we find that he has not stated that the deceased had told him that the appellant had asked him to go and die. Even if we accept the prosecution's story that the appellant did tell the deceased to go and die, that itself does not constitute the ingredient of instigation. Stop.